Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Well, I sure hope you don't have any stock in Johnson & Johnson. Let's go on down to the beach here in a second and talk about that. So yesterday, the Third Circuit Court of Appeals issued a precedential ruling in a bankruptcy case. And it's going to have some pretty significant effects on Johnson & Johnson. So here is the backstory. The backstory is that Johnson & Johnson for many years made a number of different products. They made Johnson & Johnson's baby powder, and they made Johnson & Johnson's shower-to-shower product, which was a product that was sold primarily and targeted primarily to women. And it was designed to keep them feeling fresh. Talcum powder is and has always been recognized as an aid to health and beauty. But one of the problems with talcum powder is that, like all rock products, it gets mined. And in the mining process, one of the things that was not well known at the beginning, but is well known now, is that talcum powder often has a component of asbestos inside it. So in addition to covering someone's body in talcum powder, which could lead to, feeling good and refreshed and all that, the problem with it was that you could also expose yourself to this asbestos and you could develop asbestosis. You could also develop mesothelioma. And if you used it below the belt, let's say, as a woman might, to keep dry, a lot of times it could produce or was linked to cervical cancer and ovarian cancer. So in 2019, a group of trial lawyers in Missouri tried a case called the Ingham case, and they got a $4.5 billion judgment against Johnson & Johnson Consumer Products, which was the spinoff of the original Johnson & Johnson company. Johnson & Johnson They spun off a number of companies into different divisions, and one of the divisions was Johnson & Johnson Consumer Products, and that was where the baby powder and some other things went. And that was the division that wound up getting sued for all of these talc-related issues. There is also a bankruptcy that involves Emerus Corporation, and Emerus was an entity that produced asbestos and talc. And so they have a huge bankruptcy going on right now. But Johnson & Johnson had $61.5 billion in asset value. And so a $4 billion hit on that company, while significant, was not so significant as to put it into bankruptcy. But the people on Wall Street and the people who loaned money to companies recognized it as a threat. So what did Johnson & Johnson do? Well, here is the timeline, and you can see that in 1979, Johnson & Johnson, as the major corporation, spun off its consumer products division. And then in 2022, the consumer products division spun off into the new consumer products division and LTL Management LLC. Now, the fun part here is that, as you can see in this slide, the assets of the company, meaning all of their valuable products, all of their patents, all of their trademarks, all of the things that made these Johnson & Johnson products so popular, that went to new consumer. All of the debts and liabilities of new consumer went to LTL Corporation. And then 2 days after it was spun off into this LLC that held all of the liabilities, the next thing that happened was that they filed for bankruptcy 2 days later. But interestingly enough, when they did this little spin-off, one of the things that they did is they set aside a separate fund of money called the funding agreement. And it was set off between Johnson & Johnson, the parent company, and LTL Management. And basically what it did was it provided a fund of money that could be used to pay out all of these talc cases. And that brings us to the bankruptcy. In the bankruptcy, as you saw on the slide, on the timeline, the talc claimants filed a motion to dismiss saying, hey, you guys didn't do this in good faith. And what was their evidence of bad faith? Well, for one thing, they spun the corporation off as a North Carolina corporation simply to get North Carolina venue for the bankruptcy. And the reason that was important is that North Carolina is in the Fourth Circuit, and New Jersey, where the rest of Johnson & Johnson is in the Third Circuit. The Fourth Circuit takes a three monkeys approach to these Texas two-steps, which is what this is colloquially called. And the Texas two-step is spin off the corporation, then have the bad company file for bankruptcy protection. The Fourth Circuit is a hear no evil, see no evil, speak no evil kind of court. When it comes to that, it's like, no, they filed for bankruptcy. We're not going to look too carefully at why they filed for bankruptcy or how they filed for bankruptcy. But the Third Circuit has some of the brightest and most articulate judges in the federal system. And the Third Circuit, well, they don't cotton to that. And as a result of that, one of the things that happened is the talc claimants filed a motion in North Carolina with the bankruptcy court there saying, hey, none of the rest of these companies are in North Carolina. We think this is pretensive joinder, and we want this transferred to New Jersey. So the bankruptcy court evaluated everything in North Carolina, evaluated everything, and said, yep, we're sending it up to New Jersey. So they sent the case up to New Jersey, and at that point, Johnson & Johnson and LTL got their hearing on the motion to dismiss, and the judge looked at the talc claimants and how much they were owed, and they looked at all the other things, and they said, the judge said, I think this is a situation where they filed it in good faith. The talc claimants immediately filed an appeal. It was certified up to the Third Circuit, and the Third Circuit, in rapid fashion, issued an opinion. Here is how the opinion begins. Johnson & Johnson Consumer Inc., Old Consumer, a wholly owned subsidiary of Johnson & Johnson, J&J, sold healthcare products with iconic names branded on consumers' consciousness: Band-Aid, Tylenol, Aveeno, and Listerine, to list but a few. It also produced Johnson's baby powder, equally recognizable for well over a century as a skincare product. Its base was talc, a mineral mined and milled into a fine powder. Concerns that the talc contained traces of asbestos spawned in recent years a torrent of lawsuits against Old Consumer and J&J, alleging that Johnson's baby powder has caused ovarian cancer and mesothelioma. As mentioned, one of those lawsuits resulted in a $4.5 billion verdict against Johnson & Johnson. So, picking back up with the opinion, with mounting payouts and litigation costs, Old Consumer, through a series of intercompany transactions, primarily under Texas state law, split into two new entities: LTL Management LLC, otherwise known as LTL in the opinion, holding principally Old Consumer's liabilities related to talc litigation, and a funding support agreement from LPL's corporate parents and Johnson & Johnson Consumer Inc., holding virtually all of the productive business assets previously held by Old Consumer. J&J's stated goal was to isolate the talc liabilities in a new subsidiary so that entity could file for Chapter 11 without subjecting Old Consumer's entire operating enterprise to bankruptcy proceedings. 2 days later, LTL filed in the Western District of North Carolina. That court, however, transferred the case to the bankruptcy court for the District of New Jersey. Well, As mentioned, that did not sit well with the talc claimants who had billions of dollars potentially in liability. And so one of the things that they did is they filed this motion to dismiss. And the opinion describes it this way. Talc claimants there moved to dismiss LTL's bankruptcy case as not filed in good faith. The bankruptcy court, in 2 thorough opinions, denied those motions and extended the automatic stay of actions against LTL to hundreds of non-debtors that included J&J and New Consumer. Appeals followed and are consolidated before us. We start and stay with good faith. Good intentions, such as to protect J&J's brand or comprehensively resolve litigation, do not suffice alone. So what they started out with and what they ended up with was this issue of good faith. And this is how the court described the good faith issue. Chapter 11 bankruptcy petitions are subject to dismissal under 11 U.S.C. section 1112b unless filed in good faith, and then they cite some authority. Section 1112 provides for dismissal for cause. A lack of good faith constitutes cause, though it does not fall into one of the examples of cause specifically listed in the statute. Because the code's text neither sets nor bars explicitly a good faith requirement, we have grounded it in the equitable nature of bankruptcy and the purposes underlying bankruptcy. A debtor who attempts to garner shelter under the bankruptcy code must act in conformity with the code's underlying principles. Okay, let me explain a little bit about why that's important and what we mean by equitable principles. At common law, before equity and law merged in the United States, the law courts were the king's courts, and the equitable courts were the church courts, the courts of chancery. And equitable courts operated on principles of fairness, and legal courts operated on law. Well, now those are merged in the United States, but the equitable principles that underlie the whole concept of equity, one of them is he who seeks equity must do equity. And there's also something called the clean hands doctrine. And the clean hands doctrine says you have to come into court with clean hands. If you come into court with dirty hands, we're going to kick you right back out. So how does the court resolve this issue of good faith? Well, it starts with the proper test, and here's what it says about that. We examine the totality of facts and circumstances and determine where a petition falls along the spectrum, ranging from the clearly acceptable to the patently abusive. Though a debtor's subjective intent may be relevant, good faith falls more on an objective analysis of whether the debtor has sought to step outside the equitable limitations of Chapter 11. 2 inquiries are particularly relevant. 1, whether the petition serves a valid bankruptcy purpose, and 2, whether it is filed merely to obtain a tactical litigation advantage. Valid bankruptcy purposes include preserving a going concern or maximizing the value of the debtor's estate. Further, a valid bankruptcy purpose assumes a debtor in financial distress. It then the court goes on to talk about the issue of financial distress and why that is so important and how courts have determined whether someone is in financial distress. Here is what they say. The theme is clear, and here they're talking about the theme in case law. Absent financial distress, there is no reason for Chapter 11 and no valid bankruptcy purpose. Courts, therefore, have consistently dismissed petitions filed by financially healthy companies with no need to reorganize under the protection of Chapter 11. If a petitioner has no need to rehabilitate or reorganize, its petition cannot serve a rehabilitative purpose for which Chapter 11 was designed. So at that point, the court then looks again at the financial picture, and it looks particularly at this funding mechanism that was set up. But I don't want to get a hold of myself. Here's what they say. LTL was not in financial distress. With our focus properly set, we now evaluate the financial condition of LTL. It is here we most disagree with the bankruptcy court, as it erred by overemphasizing the relevance of old consumers' financial condition. And while we do not second guess its findings on the scope and costs of talc exposure up to the filing date, we do not accept its projections of future liability derived from those facts. After these course corrections, we cannot agree LTL was in financial distress when it filed its Chapter 11 petition. At that point, the outcome here becomes pretty obvious. And here's what the court said about that. Our decision dismisses the bankruptcy filing of a company created to file for bankruptcy. It restricts J&J's ability to move thousands of claims out of trial courts and into bankruptcy courts so they may be resolved, in J&J's words, equitably and efficiency. But given Chapter 11's ability to redefine fundamental rights of third parties, only those facing financial distress can call on bankruptcy's tools to be applied here. While LTL faces substantial future talc liability, its funding backstop plainly mitigates any financial distress on its petition foreseen on its petition date. As a result, the Third Circuit dismissed the bankruptcy petition. So now L&L is right back on the hook and must defend in the trial courts all over the country and in the mass tort litigation that is currently pending at the Multi-District Litigation Forum. It has to defend those and continue paying costs of defense and try hard to work out a settlement out of bankruptcy court. Only if J&J and its funding provision become subject to some other lien or get taken in some other fashion, is it going to have a right to seek bankruptcy protection. So what does that mean? Well, it means that New Consumer, the company that was spun off and has all the assets, is now just as much at risk as LTL. The Texas two-step actually accomplished nothing here. This is a terrific decision by the Third Circuit because it restores some balance. It reminds me of that thing in the Star Wars universe where they say, the new person is going to restore balance to the Force. Well, here the Third Circuit restored balance to bankruptcy law. And it says, look, you're a $61.5 billion corporation. You don't get to come in and claim that $4 billion has put you into bankruptcy. It's a good decision, like I said. So there we have it. If you have any questions about the outcome of this case or any of the analysis in the opinion, I will try to link the opinion. I did a prior version of this case. I talked about this case earlier in an opinion. I will try to remember to link that up there. I am terrible about that, by the way. I often don't think to link things, so if I miss that, please let me know. But I will link that in the description, and if you have any questions, please feel free to leave them in the comments down below. Thank you again so much for your feedback, for your subscriptions, and as always, try to be kind today. Try to help somebody out. It'll make your whole day. Have a great day, guys. I'll catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.